So let me start with some of the background and just say we, shortly after Alice, when we were deciding what path to go, we were in this conundrum of knowing that we have a disruptive case, to use Russ Leifer's words from a minute ago, and one of the conundrums was not knowing necessarily what direction the courts were going to go after Alice. So we took an approach in our guidance that came out in December of 2014, which we've called 2014 interim guidance. We took the approach to do a case law matching process where we were telling examiners, when you have a situation in front of you that is similar to a decision by the courts that they've held to be ineligible, then you also have that same situation. And again, I know people are familiar that that's what we did, but going behind the reasoning of why we did that was because not knowing what direction the courts were going to go and having only a small subset of, Alice and then maybe a few cases shortly after Alice, it was very hard for us to do what we typically do, which is have some unified approach, not based on a claim to case law matching, et cetera, like we did here. But we thought that this was the right approach to make sure that we were sticking very closely to what the courts did, to make sure that examiners were not, and the office as a whole was not overextending what the cases said. And so we really tried to have examiners match their situation to the case law. And I do think that that was the right decision. I think it would have been very challenging for PTO at that point to have some kind of process other than matching to a particular case, given, as I said, we had just had a case with a significant amount of change. But the problems with that approach are that it's really not a long-term workable solution.